And so our next speaker is Patricia Adair from the regulatory side, and really just looking at what you need to know. Certainly from our point of view, Mike did talk about contentious, and we have spoken to a number of solicitors who specialise in the contentious side. What tends to happen is if you hit a problem, at that point you hand it over to solicitors. They don't steal the work. They deal with the legal problem and then they hand it back. So, you know, there's never an issue. Even where they've got their own probate department, they say it would be suicide if they stole the work from an introducer. So, you know, there's never a fear there. Pat, over to you. Thank you very much.
Thank you. I'm Pat Adair. I'm the Regulatory Policy Manager at ICAEW, and I was responsible for the application to regulate probate services. And as Vernon mentioned, I'm currently drafting the second application to apply for the next application to the Legal Services Board to regulate the remaining legal services. What I'll be talking about today is giving you a brief overview, just reiterating what Vernon said about why we applied to become a legal services regulator, some of the benefits of actually setting up an alternative business structure, if firms want to apply, how they might be able to apply, and what our intentions are for the future. Now, when the Legal Services Act was introduced in 2011, it basically introduced a new regulatory regime which for the first time permitted lawyers and non-lawyers to form businesses together and to allow non-lawyers to get involved with management and the ownership of businesses that provided reserved legal services. Now, it's important to distinguish between reserved and non-reserved legal services because you need to get accredited to do those 6 reserved legal activities, because if you conduct that kind of work without accreditation from a legal services regulator, you would in fact be committing a criminal offence. All other services are non-reserved, and non-accredited people can carry out that type of work, but of course you do need to be competent to do so. So quite a few firms actually employ solicitors to carry out those services. Now, Vernon's touched on the reason why we applied to regulate probate. It was really a natural adjunct to accountancy practice. Many firms were already doing estate administration work, so it was a natural progression. We'd just come out of a recession when we were considering making the application, so obviously firms had possibly lost work due to that. We wanted to enable them to expand their businesses in new innovative areas, and of course there was always also the reduction of audit work. We felt it would also provide firms with the ability to provide their clients with a one-stop shop for services. Those doing estate administration had to cut short and go to solicitors to deal with the probate areas. If they gained accreditation, they wouldn't need to do that, which obviously would have saved money for their clients. An additional benefit of accreditation brings legal professional privilege as well. And that legal professional privilege doesn't just attach to the probate work, but it also attaches to the estate administration work. Now, some of the benefits of alternative business structures are that I mentioned that a lot of legal work is non-reserved work, but of course you would need to be competent to carry that out. So quite a few of the bigger firms actually employ solicitors. If you're a non-ABS, in-house solicitors can't provide legal advice to your clients. They can only provide legal advice to their employer. But if you set up an ABS, those solicitors can actually provide legal advice to your clients. And that's quite a lot of different areas. If you think that most legal firms, approximately 80% of the solicitors' work is non-reserved work. Now, this is a snapshot of a website of a City of London law firm. And you'll see here that there's quite a lot of overlap between the type of services provided by accountancy firms and those provided by solicitors. So you'll see there the scope for providing non-reserved legal work in addition to the reserved area that you're regulated to carry out. Now, if anyone is interested in applying to be credited for probate, all the information to make the application can be found on our website at that address, icaew.com/probate. That area of the website contains all the application forms and information on how to apply. It also gives you information on the qualification criteria for individuals who need to get individually authorised to carry out the work, and it also gives information on our fee scales. There's basically two applications that can be made to authorise your firm. It really depends on the size of your firm as to what would be appropriate for you to make an application. Authorisation is for a firm where all principals and owners need to be individually authorised. So it's really only very small firms that practically could apply to become authorised firms, because not all accountants in an accountancy firm would necessarily want to be authorised to do the legal services work. As Vernon has mentioned, about 3/4 are applying to become ABSs to obtain a licence, because the criteria for that is that just one principal needs to be individually authorised in order to become an ABS. So only one principal would need to be authorised to carry out probate work. There are, however, additional regulations in relation to ABSs. Unlike authorised firms, you would also have to appoint a head of legal practice who would have to be an authorised person, so they would have to become qualified to carry out that legal service. You also need to appoint a head of finance and administration, and they need to have appropriate qualifications, such as perhaps an accountancy qualification. And an additional area is that non-authorised owners with a material interest have to apply for us to give them permission to remain non-authorised. A material interest is generally about a 10% shareholding or ownership. So you'll see there's additional things to be done in relation to a licence, but as I say, it's probably not practical for a firm with more than, say, 2 or 3 principals to become an authorised firm. In addition to applying for your firm to be accredited, anyone who's going to be carrying out the work, authorised work, needs to be individually authorised themselves if they're going to be supervising it or carrying it out. Under the probate regulations, there's 3 regulations that you could possibly apply under. The first is for ICAEW members who obviously have the ACA qualification. The second is for applicants who are authorised by other legal services regulators, and those would be obviously people like solicitors and barristers, and those who we term otherwise qualified. And the type of applicants making applications through that route are, for instance, other accountancy body members such as ACCAs. We also get applications from members of the Chartered Institute of Taxation and also people with the STEP qualification. And those with the STEP qualification who have done certain of those qualifications do actually get an exemption from taking the SWAT course and passing the assessment. So as far as those who have to actually take the course and pass the assessment, it's going to be those coming through the first and third route, ICAEW members and those otherwise qualified. Obviously, those authorised by the legal regulators already have their qualification and so can automatically be authorised. Now, if you're interested in going on the course, the details can be found there on the SWAT website on that address. So, as far as making applications concerned, you need, if you're going to apply to become either an authorised or licensed firm, you need to appoint either a contact partner for an authorised firm, or if you're going to become an ABS, you need to appoint a head of legal practice and a head in finance administration. But either way, an authorised firm, all the principals have to be authorised and all the owners, but for a licensed firm, just one principal and the non-authorised owners. So also you need to apply for non-authorised owners to be approved, but there's also an application for probate affiliates. Anyone who's not already within our disciplinary bylaws, such as those registered for audit, need to apply to become probate affiliates so that they come within the ambit of our disciplinary bylaws. The particular areas of consideration when we're looking at your applications, an important area is ownership. That's why we ask for non-authorised owners to apply for permission. We look at fit and proper issues to make sure that all the principals and non-authorised owners are fit and proper people. And most particularly where there's a corporate structure is complex, we look at the compliance arrangements the management structure and the reporting lines for those conducting probate work, just to make sure that we're happy with those compliance procedures and that there's proper supervision and there's not undue control of the business by those we don't deem suitable. We also carry out criminal record checks on certain individuals. We carry out, as far as those applying under the third route as otherwise qualified, they'll have to make a basic check on themselves and provide that information in their application. But as far as heads of legal practice, heads of finance administration and applicants applying for non-authorised donors, we have to carry out what's called a higher level standard check, which checks both spent and non-spent convictions. These are carried out by an agency that are authorised to carry out such checks. And so when you're making your application for individual authorisation and those appointments, that agency will actually get in touch with you by email and ask you for certain information. There are annual fees to pay each year. There's a registration fee to pay, compensation levy, which we are bound by law to provide. And the fees are calculated on the type of firm, i.e. whether or not you're an authorised firm or a licensed firm, the number of principals, authorised individuals and affiliates, and the number of officers you register to carry out the work. This is an example of our fee scales for an ABS. So you'll see it depends on the number of individuals and the number of offices that you're applying to register to carry out the work. The regulations also cover consumer protection issues. Under the Act, firms providing probate services will have to provide a first-tier complaints procedure, which should last for approximately 8 weeks, and you'll need to signpost those that you're engaging with in engagement letters to tell them that after 8 weeks, if any complaint they've made is not resolved during the first tier of the complaints procedure, after 8 weeks they have the right to refer the complaint to the legal ombudsman, and that would be in relation to service complaints. As mentioned earlier, there's also a requirement for professional indemnity insurance, which is currently a minimum level of indemnity of $500,000 per claim. So as Bernard's mentioned earlier, we're just drafting our next application to the Legal Services Board. We're applying to do all remaining reserve legal activities, the first 3 of which listed there, conduct of litigation, rights of audience and reserved instrument activities, will be restricted to the service area of taxation. But as has been mentioned too, our probate application took an awful long time to get through. One of the main reasons was because it took a long time for the Ministry of Justice to draft the necessary statutory orders and to get it through the parliamentary timetable. This is the reason why we've gone for the remaining reserve legal activities, but we want to restrict it to begin with to an area that we know that accountants are more than competent to carry and experts to carry out. But the benefit of this is that once we get designation, if we do, to carry out these reserve legal activities, if we then want to expand these activities to other areas in addition to taxation services, it wouldn't have to be a full application to the Legal Services Board. We would simply have to make an application to the Legal Services Board to amend our regulations. It wouldn't require statutory legislation to go through Parliament in order to do so. So it would be a much quicker exercise. It would just mean applying to the Legal Services Board to extend our regulations, which would be a short consultation process. So it means that we've got a quicker ability to expand as and when members require us to do so. So I'm now going to hand over to Janet to talk about the quality assurance procedures.
Good afternoon, everybody. It's nice to be here. I've got 10 minutes, so I'll keep it quick. And I am the free part of the buy one, get one free that Mike referred to earlier, because my name isn't in your programmes. I'm Janet Hartas. I'm a senior manager in the Quality Assurance Department, and I look after the Practice Assurance Scheme. One of the key parts of our application for probate was that we would carry out monitoring, And we would wrap that in the practice assurance scheme monitoring, which is why I got involved in this. So I now look after the probate team as well. So I'll just put that hat on for the moment. So very quickly, I'm going to tell you what to expect if you get a visit from QAD to look at probate and estate management, and what you can do to prepare. So all of our probate visits are on site. Some of you might have had practice assurance visits by telephone or by a desktop review, but all of our probate visits will be on site. We've agreed with the LSB as part of our application process that we'll see all of our probate applicants, successful applicants, within 24 months of being granted an accreditation. So if you apply, you can expect us to turn up on your doorstep within the next couple of years. Now, we will give you some warning, so don't worry, we won't just arrive with our briefcases. Our head office team will phone you in advance to agree a suitable date with you. And they'll usually ask you if you've done any probate work, because we've had a few visits in the early parts of this process where we did go and they hadn't actually got anything for us to look at, so it was a bit of a waste of time for everybody, frankly. So, well, no, that's unfair. I'm sure everybody got value out of it. I'll just retract that, as my boss is here. But the ideal situation, clearly, is that you have done some work, that there's at least a couple of cases for us to look at so that we can see how you're managing those cases and hopefully give you some sensible advice to help you comply with the regulations, which is what our job is. So the purpose of the visit is to make sure that you understand the probate regulations and that you've got clear procedures in place to comply with the requirements of those regulations. It isn't a technical review. It isn't like an audit review where we would come in and look at the technical quality of your files. It's more around the procedures and the compliance aspects. So I think that's important to remember, that we won't come in and test the nuts and bolts of what you're doing, but we will have a good look at your files, at your client files. We've done about 40 visits to date, and we've got another 50 or so scheduled for the rest of this year. And I've got a team of about 8 probate reviewers, so it's a small team who've all been trained. They're part of the wider QAD practice assurance team, but they specialise in probate visits. So you will be visited by somebody who is qualified and has done quite a number of visits by the time they get to you, so they can share experiences. The visit will also cover practice assurance at the same time, so we'll wrap those together so that it's more efficient for you. If you have recently had a practice assurance visit, which is possible as we've got to escalate the probate visits, then it'll be a very quick, light touch practice assurance visit, just following up on things that we talked to you about the previous time. When we schedule our visits, you'll receive this booklet, which is called Practice Assurance Visits, so it looks like this. It actually covers probate as well. So within that little booklet, there's a list of things that you need to consider, things that you need to have ready for us when we come in to do our visit. We'll start our visit with an opening meeting, and that opening meeting is to find out what sort of work you've been doing, what your client base is, how many cases you've had, what the status of those cases are, if it's work in progress or they're complete, what sort of fees you're getting. So as Mike said, when we visited his firm, they very helpfully had a list which gave us all of that information so we could select files for review from that list. So it is a good idea, if you've got a visit coming up, to pull something like that together for us to make it a quicker process for everybody. We'll also talk to you about, at the opening meeting, about what your procedures are, how you manage the visit, how you manage the work, how you manage your team, what staff do the work, and how you endeavour to comply with the probate regulations. But we'll then test that by looking at various pieces of documentation and dipping into some client files to look for evidence that you have actually done what you told us you would do in terms of procedures. At the end of the visit, we'll sit down with you and talk through our findings. We'll give you a set of closing meeting notes. I'm sure a lot of you are familiar with the way we work already. It's no different to a practice assurance visit. So we'll sit down and talk through our findings, and we'll then give you 15 business days to respond to our findings. And if you give us sensible, clear responses, 9 times out of 10 we'll close that visit down with no further contact from us. That will all be done. So what do we look at in a bit more detail? Procedures I've already mentioned, so we're interested in how you actually run your office. What procedures have you got in place for getting a client from the beginning to the end of the process? Training. Most of the people that we're visiting, the AIs, will clearly have done the training, but they'll have a team who are actually carrying out a lot of the work. So what training has the team had? They might not have been on the SWAT course, but we would expect you to have given them the relevant training that they need to be able to do the work competently. And we're coming up now to nearly 2 years for some firms that have been licensed. So we'll be asking, well, what about ongoing CPD for those of you who did the SWAT course? Have you thought about that, topping up your knowledge? Quality control, mentioned that already. Very, very important that the AI has control of the work, that they oversee, supervise, and understand what their team are doing. So we'll be looking for evidence of direct involvement from the AI on the files that we look at. And we'll talk to the staff and get an understanding from them of how the process works from their perspective, so what level of supervision they get. Engagement terms, there are a few things that you need to make sure you've got in your engagement terms with your probate and estate management clients that aren't the norm. So I will mention again the 500,000 PII per claim level, because that needs to go in your engagement letter, but there are various other bits and pieces that need to go in there. They're all in the templates. There are various templates available, and most of these things are flagged quite clearly, certainly on our website as well. Marketing, there is a legend that you can use when you're probate accredited, so we'll look to see if you are using it, that you've got the right one. But we'll also look at, we'll talk to you about how you're marketing your practice. Mike mentioned that they have been, up until now, doing a sort of soft marketing, which is the case for a lot of our firms that we visit, to be honest. But some are more commercial and have actually been developing some marketing literature. So we would look at that to make sure that it's consistent with our code of ethics. PII and complaints, I won't labour PII, but complaints, we do ask if you've had any. But more importantly, we're interested in your procedure for dealing with complaints. So if you did get a complaint, how do you process that so that you can comply with the additional requirements around notifying the Ombudsman? Clients' money and assets, big area, obviously. You have to comply with the client's money regulations as part of the probate regulations, and we will look in detail at how you're managing those clients' assets. Clearly, it's very important to us that ICAEW members and their affiliates are protecting their clients' assets. Compliance review, there's a requirement in the probate regulations for you to have an annual compliance review, or to carry out an annual compliance review. A lot of the firms we visited to date haven't passed that year, so we've just been reminding them about it as we visited them. But we're now getting to the point where we'll expect to see some evidence of a compliance review being done. And lastly, diversity monitoring. So again, this is a requirement of the regulations that you have in place a process to monitor diversity within your practice, so that if we ask you for evidence of that, you're able to present it to us, and that you could publish it if you needed to. And there is some more guidance on our website about how you can go about monitoring diversity. Those are all of the things I wanted to mention in terms of how we go about our visits and what you can expect. The main thing is not to be worried about it. The purpose of the visit is to make sure that you know what you need to do, and that gives you an opportunity to correct anything if necessary. What I would mention is that we've recently produced a short article, very recently, I finished it yesterday, which is a summary of our findings so far on our probate visits. That'll go on the website over the next week or so, and you should get a practice alert email, which will have a link in it. So do have a look for that. If you see Practice Alert come up with probate guidance on it, don't delete. Please open it, and you can see what we've found so far. Thank you.